Good afternoon. My name is Rugi Canizares, and it's a pleasure to see a lot of familiar faces. And again, my name is Rugi Canizares, and I'm your current treasurer. And I'm thrilled to be here to be your host for today's Regulatory Hour webinar. FSPPT is so fortunate to have Dale Atkinson on an ongoing basis. To highlight his background, Dale received his law degree from Northwestern School of Law, Portland, Oregon, and is the sole managing member of the Northbrook, Illinois law firm of Atkinson and Atkinson, which represents various associations of regulatory boards. In addition, Dale represents associations in all matters relating to their operations as not-for-profit corporations. This includes regulatory activities, education and accreditation, disciplinary actions, and other functions per previous introductions. He is a frequent speaker for his association clients as well as other regulatory groups, and also produces numerous subject matter writings for publications. Without further ado, I am pleased to have Dale present today's regulatory hour topic, the conflict zone, conflicts and solutions. Go ahead, Dave.
Rugi, thank you so much for that introduction and welcome. And I too will express my thanks to everyone on the line. You guys can hear me, right? Give me a thumbs up. Somebody give me a thumbs up that I can say excellent. I too will express my thanks for you all being here. Welcome to the June Regulatory Hour. We are going to talk about conflicts of interest, but I do want to recognize FSBPT, its staff, board of directors, and all those involved in putting these seminars, if you will, together. Both the regulatory hour that occur monthly, and then you have many others that you have access to. So take advantage of those as regulators. So many thanks to FSBPT for putting these on and having me be involved. The biggest thanks goes to you all as regulators. It's a tough time to be a regulator right now for a host of reasons, from COVID right on through to regulatory climates and political issues that do surface. And so a big thanks does go out to you for the important role you play in public protection, in the volunteer services that you provide as appointed board members, and of course to staff and others that are involved at the state and provincial board level. So you are to be thanked, and I will do that now sincerely. And sometimes I try to be funny on other things, but let's get these thanks going and make sure we understand that and are clear. Today's issue is about conflict of interest, and it's actually a terrific topic to spend a little bit of time on, in part because I think a lot of people, a lot of regulators, let's call it regulators, a lot of regulators know what conflict is or feel they know what conflict is, and so it somehow falls into a back burner situation. And I think that it's important for us to identify some of the roots of conflict-driven issues and government involvement. So we'll cover some of that. But I do want to emphasize that if you all have something to say, please type it into the chat. I'll keep an eye on it, as will Jeff and Rich, and they can chime in, and Rugi, they can chime in and ask questions as well. But I encourage you to participate, and we try to make these sessions as interactive as possible. This is one of the benefits of the pulling you all together into the same room, if you will, or at least on a video basis. So feel free to chime in, unmute, or use the chat room and speak up. So back to conflict of interest. It's something that I think people just feel they know what it is and why it exists, and then it doesn't surface as often as perhaps it should from a standpoint of discussions, identification, and then solutions that eventually that do come up. And so we'll take the time to try to go through that exists. But as is customary with me, you all get to pick out which animal best identifies your mood right now as it exists. So type it in the chat room and throw it in there. This is my way of, one, bringing a little laughter to this, and two is to make sure you guys are listening, and three is to make sure you know how to operate the chat side. So these are fun kitties, and we've used previous animals in different months, and so I will try to do this as well. I see a 10 out there, so if we've got some aggression we need to get rid of, that's okay too. But if there's a 5 or 2 out there, is that you're falling between the cushions on the couch and you're not sure what's going on versus you're just relaxing. So take advantage of that. As mentioned, my name is Dale Atkinson. It is also customary. I'll put up a picture of some TV or actor lawyer, that really isn't me. That's up on the screen. But as mentioned, I am an attorney. I'm a consultant to FSBPT, and I represent a whole bunch of other FSBPT-like organizations. So the only reason I'll spend a little bit of time on this is to remind you all that you are not alone as a regulator. You have other boards and staff within your state, intrastate. You have other physical therapy boards interstate. You have FSBPT to pull you all together as that collective, to bring the collective wisdom together. And FSBPT has a whole bunch of other FSBPT-like organizations. So while the regulatory community is small, you are not alone, and you do have access to others that may be helpful, including myself. And so feel free to take advantage of that and participate, identify who's on the calls, get some names, and figure out ways that you can best communicate. And that's one of the main reasons FSBPT-like organizations exist. Lastly, is most of my clients develop, administer, store, and maintain a uniform licensure exam program like yours. And so that's part of my representation of the various clients, the FSBPT-like clients. So I do a lot of board member training, and I do a lot of sessions like this and talking about issues. And as I've mentioned and emphasized, what motivates me is not only the public protection driven issues, but the ability to get you all to talk or to chat or to say a few things so that we can garner some discussion out of this and meet the needs of you all. And also, as is customary, it's fair game to always talk about hockey and the Stanley Cup. We're in the throes of some great playoff games, so it's okay for you all to bring up hockey. So if I ask somebody a question and you don't know the answer, just talk about hockey and you're going to be in good shape. So as mentioned on the slide here, please unmute and participate. So today we're going to talk about the conflict zone, conflicts and solutions. You see the recap of what we've already talked about in the first several months of the year, and then you see the upcoming topics that we will eventually go over. So hopefully this sets up in a nice manner to allow us to build upon our knowledge. And in the end, after every one of these sessions, I hope you all feel a little more comfortable about being a regulator, and also a little more comfortable about asking questions and engaging in the dialogue that needs to happen. So the conflict zone is where we will focus today. So in the chat room, go ahead now and describe what how did I word this? I got to move my pictures around here a little bit. Describe what you are related to your board itself. So you can be a licensed physical therapist member of the board. You can be a licensed or registered or certified physical therapy assistant member on the board. You could be a public member. You could be an other that I might not have thought of, and perhaps some of you maybe don't know. I think you probably do, but so go ahead and put those numbers in there. This gives me an idea as to the perspectives that you bring to the table. And in my mind, this kind of knowledge and this kind of data is very important when we talk about conflict of interest issues or driven issues, because of the fact that can we trust licensees to regulate the profession through a government driven program? And that's a question that is being asked. I think the answer is clearly yes to that. But how do we best do that? We do that by being informed members, and that we are not here promoting the profession. We are here enforcing the Practice Acts in the interest of public protection. And those that are licensees, or as the Supreme Court calls you, active market participants, you have to ensure that the perspective you bring to the table is driven by the Practice Act and public protection, not by professional promotion and other issues that might surface related to that. And so one of my pet peeves when I deal with trainings and I'm interacting with people is there's a lot of this our profession issue. And for some reason, I just try to correct that. At least in my head, I correct that. It's not an our profession, it is a profession, and you all are being asked to regulate it. And the reason that this kind of perspective is important to emphasize is because of the conflict principles we're going to talk about. And politically right now, both, I should say politically and legally, the challenges that surface are asking the very questions of, can we trust licensees to regulate their professions? And some might ask, does that mean it's self-regulated? Of which, to me, the answer is a definitive no. You're not a self-regulated profession because of the involvement of government. We're going to get into that in a minute. But we are asking licensees to be involved in the regulatory process because, and everyone should know this answer right off the bat, because it makes for a more efficient process. You all bring expertise to the table, and I'm not pushing aside public members, by the way, but you all, licensees and others, you bring expertise to the table that is needed in order to have an effective and efficient system of regulation. So I've said that I feel like in every one of these monthly regulatory hours, and I'm going to continue to say that, but it's probably very applicable to today's topic. So you can identify yourselves as one or other in that particular slide. So why is this such an important issue? Does somebody want to unmute and tell me why is conflict of interest such an important issue for us to address from either a legal, practical, or any other perspective you might bring to the table? Anybody? Let's see if we can get somebody to talk. We give away some big prizes for the first person to talk. Last month, I think it was a trip around the world, FSBPT. Do you remember that? Perhaps not. Okay, anybody, why is this such an important issue?
We should appear impartial
Absolutely. And why do you need to appear impartial?
so that we're making good judgments that can be relied on.
Okay, excellent. And those good judgments and impartiality that are being spoken of now can drive legal conclusions or legal issues or legal challenges, eventually at least. So it's an extremely important topic for us to ensure that we have an understanding of how that works. Okay. So somebody else now unmute and tell me, what is conflict of interest? And there's no right and wrong here. No one should feel intimidated. If you get stuck, just talk about the Stanley Cup, you're fine. But somebody tell me, what is conflict of interest? Maybe throw in some extra credit here. What's bias? And are there some examples? So for instance, is anybody on the line, have you recused yourself lately from a board proceeding based upon a conflict of interest principle that you're willing to share or make up? It's okay, hypothetically. There are 31 people on the line. Somebody can unmute. Go ahead. Let's go.
Sure.
What's conflict of interest?
I'm in Idaho.
You all don't like to be put on the spot? How about examples? Anybody been in a board meeting lately where someone has recused? What happened? How did that all pan out?
Deanna, let's try again. Deanna and I had an answer for you, Dale.
Okay, go ahead.
So now can you hear me?
Yes, I can.
Okay. I serve both on the board and as a faculty member in a school. And so I had to recuse myself on issues that come forward when they are graduates of our program.
Excellent example. And so look at the roles that are played now by Deanna and her understanding of that. She serves on the board in an appointed capacity, enforcing the Practice Act in the interest of public protection. She has a job, she earns a living, she is a professor in an educational program, and those two may eventually have to cause a recusal depending upon the circumstances. And we are going to talk about conflict of interest throughout obviously this whole hour today, but I don't want anyone to feel like the sky is falling and that you must recuse every time we turn around. Recusal is a very personal issue to you all, and it's saying to the world that my objectivity is perhaps at question here, so therefore I am not going to participate in the process as of now. So there's a good example. She has graduates from a program, and she may step aside on either a licensure decision to grant the license, perhaps renewals or others that might surface. So anyone else want to unmute and tell me what bias is?
When I was chair of the board and there was a complaint to a direct competitor who hired our office manager in a very small town, I had to recuse myself because of the possibility of the optics that the outcome of that disciplinary action might be something that would be viewed as competitive.
And a great point, even the optics of it. And the case that we are going to talk about at the tail end of these slides is on that very point about the perception, if you will, of conflict that may surface. that at times could give rise to causing the need for a recusal or for the board to not participate and for another decision-making body to be appointed. And that can happen on rare occasion under certain unique circumstances where the entire board perhaps has to recuse itself. There's a lot of issues that can surface out of this. So what are the consequences of a conflict or being in a position where bias affects your ability to be a decision maker? What are the consequences, anybody? What do you have to do? Recuse, right? And the consequences might be, now you have one less board member who can participate. And we can see a host of issues that might surface out of the conflict and then the ultimate recusal. And that is, do we still have a quorum, or do we recalculate how the quorum, the quorum number that's at stake? So we'll get into a few of these as we go through the rest of the slides, but the idea here was to get you all to unmute, to get you to participate, and to get you to use the chat and or speaking options that you have. So conflict of interest is fundamental to the very nature of government regulation. And I'm not sure we emphasize this enough as those involved with training, or if you have received some training back at your state level, once you were appointed, if the assistant AG comes in and talks about it. But it's fundamental to the nature of government regulation. And what do I mean by that? Well, government has determined at some point the need to be involved in regulating the profession of physical therapy and physical therapy assistants. And I just chose to put up the FSBPT Model Act, Article 1, Section 101, as an example where government is telling the world out there through the enactment of statutes that the purpose is to protect the health, safety, and welfare, and only allow those who are competent to engage in the practice. And that is through the issuance of a license. So what does that tell us now? That tells us that government has made this determination that a profession is in need of regulation and health, safety, and welfare is at stake. Okay. Now, while we're on this Article 1, Section 101 of your Model Act, the very last sentence is extremely important. Since it's on the screen, I'm going to read it and at least emphasize it. This act shall be liberally construed to promote the public interest and to accomplish the purposes stated herein. Extremely important for the legislature to tell the judicial branch that you liberally construe this in the interest of public protection, meaning when there's a matter that comes before the judiciary through, say, ambiguous language, that they know liberal construction is expected of that court in ultimately determining the outcome of the litigation itself. So while it may not be directly related to a conflict of interest, it's an important point to see. So as you all read the Model Act or read your own practice acts, that you start to have some of these phrases and concepts jump off the page at you. So now that we've decided government is involved, has decided it needs to be involved, this triggers certain rights. And so one, government mandates licensure. So I cannot practice physical therapy without a license. And there are consequences to me not getting a license, okay? A professional license is a property interest that's recognized, at least therefore then triggering certain constitutional protections. We'll get to that. Non-compliance, meaning if I don't get a license and I continue to practice or start to practice, there are criminal and administrative consequences. There may be civil consequences too, but non-compliance has its consequences. So we have government being involved, we have the creation of a property interest, and we have consequences for non-compliance. Okay? Before an adverse action can be taken against that property interest, your license, the process to be followed must be fair. And this may seem very fundamental to everyone on the line today, but it's important in my mind to walk us through these steps to get us to the conflict question, to have an understanding of why it's even important and an important concept. So before that adverse action can be taken against the property interest in the license, there must be a fair process because of what's at stake: government mandates, property interest created, non-compliance consequences, and fairness. What's a fair process? Well, due process, in my mind, is just fairness. And when it comes to the layperson, the non-lawyers, and when I do all the board trainings I do, I just say the only thing you have to remember is fairness when it comes to due process. Do your own gut check. Let the lawyers handle it from there, but it's a fair process, okay? And fairness, part of that fair process among other things, is the decision-making is done by a fair and impartial tribunal. The decision makers have no positions of conflict or bias that might adversely affect the property interest at stake here. And this due process concept is recognized by both federal and state constitutions. So it is ingrained in the systems to ensure that a mandated licensure process is fair. And that fairness, by the way, applies to everyone involved: applicants, licensees, complainants, the board members, staff, assistant AGs, and others. There's protections built in to assure that that process is fair and it's not subject to undue influence or threats of litigation or others. So what might cause a respondent to challenge the impartiality of the decision-making body or the decision makers? And it's important to understand the distinction between the decision-making body, the board as a whole, which is going to be 7, 9, 11, 13 individuals, wherever you are, and the individual decision makers. So that would be Dale, who's on the board. And is Dale impartial, and can he objectively participate in this process, thereby creating a fair process for purposes of all those involved in the adverse action? And I'm using an adverse action approach because it's the easiest to identify the issues, but everybody needs to understand that conflict principles and bias apply to all the board activities. It does not need to be that there's a complaint filed against Dale, I'm in front of your board, and my license is at stake. It could be the decision-making process to promulgate some rules. It could be a further refining or defining of the scope of practice. It could be related to recognition of continuing education programs or providers, recognition of educational programs or examination programs, or anything that might surface. So conflict should be front and center on everyone's mind. And it should be, again, not overwhelming what you how you react to it, but you ought to know about it so that when it does surface, you recognize the issue and then you seek some advice and you either take action or you don't take action, whatever the case might be. So anybody want to unmute or type in the chat room what might cause a respondent to challenge the impartiality of a decision-making body? Anybody have any, why would this surface? Perhaps an adverse action that affects one's license. It's removed, it's suspended, it's placed on hold, it's not renewed, it's not granted. And all of this now eventually will potentially bring up conflict questions. Conflict of interest issues, by the way, or bias, are lawyers' kind of go-to issue when the facts aren't on their side. So I'm in trouble on the facts on this side. I'm going to challenge the process. I'm going to start looking into the background of board members. I'm going to create some issues to try to best protect the interests of my clients. I don't say that doing it in a frivolous manner. I just say that these issues do surface when lawyers perhaps don't have the facts they might want. So they're going to create process-driven questions to again, try to best protect the interests of that. So a comment just came in about North Dakota, right? Indy, and North Dakota has had more issues with dissatisfied complainants. That's a very, very important topic that I think that FSBPT can put on its list of potential future topics, is how boards deal with complainants and the continued communication that should go on. I file a complaint, it's quiet, I'm not sure what happens. Maybe the matter is dismissed or it's outside the scope of the authority of the board, and I may not hear back from it, or you all as a regulatory board negotiate a resolution and I may not be happy with that resolution. Perhaps I can't even find out what that resolution is. So that's a really good point. That's a really good future topic for Jeff and Rich to maybe make a note about. So thank you for that. So the biggest picture issue of what might cause a respondent, and I'm using respondent to be the adversely affected party. So as I mentioned, it's way broader than just the adverse actions or the disciplinary or enforcement side of regulation, but let's just keep it for respondent for right now. And that is actual bias, or the actual bias, the appearance of bias that could be individual or it could be board or group. And to define these terms is not the easiest thing in the world necessarily, because bias is personal. And it's something that we're going to get to in a slide in just a minute as to how you handle it as a board member. But actual bias might indicate that my worst enemy has been charged. I'm on the board. My worst enemy has been charged with alleged wrongdoing, who's also a licensee. I'm a licensee, and this person I do not like for whatever reason, and it's known. Maybe we have competing businesses. Maybe we politically ran against each other, whatever the case might be. And you can point directly to me and say there's an actual bias that I can identify. The appearance of bias or impropriety is a much tougher issue to define or describe. And that might be related to the indirect relationships that either existed or didn't exist that indicate that I cannot be fair and impartial in any potential decision-making on the issue before the board. Issue the license, deny the license, renew the license, administer an adverse action. But that appearance issue is the case one of the cases we're going to talk about in a few slides. And as I've mentioned, it's individual. It could be Dale, an allegation that Dale is biased. It could be the board or the group as a whole is biased. Now you can see I've moved away from the phrase conflict of interest, and I'm emphasizing the word bias. And in part, it's because how do we define these? And actually in my office, with the lawyers in my office, we had a debate about this issue the last couple of days does conflict of interest cause bias, or does bias cause conflict of interest? That may not be important. Part of the reason I use bias is because it's shorter, it's easier to identify, and I think it does identify the legal issues that may surface. But so let's start with, what is bias? And I asked you earlier, and you all were thinking about it. Prejudice in favor of or against one thing, person, or group compared with another, usually in a way considered to be unfair. So there's our fairness issue. Does bias create a process whereby legally the actions are suspect and perhaps subject to being challenged and ultimately overturned by a court? Okay, so prejudice in favor of or against. Conflict of interest, and I can't remember where I pulled some of these definitions. These are part off of dictionaries and otherwise, and part probably in Dale's head, but a situation where the concerns of or aims of two different parties are incompatible. And so I kind of like that definition. But in the regulatory perspective, let's rephrase this definition to include a one-party issue where you may have incompatible interests, because that's where conflict and bias are going to surface in your guys' world. You individually are trying to serve two issues or two entities or two concepts that may have surfaced. And can I serve them both in a manner that is fair and impartial to, let's say, both? And so Deanna already brought up, if she is a professor at a university and she is beholden to the university, that's her employer, and she works there and does all the right things, when she's now over on the regulatory side, can she be impartial on a person from her program that is coming up for, say, licensure, or perhaps coming up for an adverse action? A complaint maybe was filed, or a renewal issue, or when the educational program wants to be recognized as an educational program that qualifies an individual for that one criteria toward licensure, and that is I've met the educational requirements. And I realize there's an accreditation process that does that. But in the end, Deanna is wise enough to say, well, gee, can I serve both of these, what may be at times incompatible interests, or might it create an appearance of impropriety or conflict or bias? And so when we turn now to you all as regulators, and that is, can your interests serve multiple factions? Now, where this comes up most often is when we have licensees populating boards. Those licensees belong to the trade association, the APTA, or the state chapter, or the local chapter, if you have those. And can those interests then also be served when the individual who is a licensee belonging to these trade side groups also then serve the public interest? And what happens when those interests perhaps become incompatible? And they do, believe me. Or, as I mentioned earlier, when I'm a lawyer searching for ways to best protect my client, this is where I'm going to focus. And I'm going to focus on the fact that This so-called self-regulation, which I don't believe you're self-regulated, but I'm going to use that phrase. This so-called self-regulation has created a system that isn't fair. And these individuals who bring a trade perspective to the regulatory issues is just keeping people out of the profession, or it's just protecting the scope of practice. And this comes up a lot. And this is where the legal issues start to surface, and this is where the challenges will come. And there's litigation all over the place historically that addresses these issues, especially these overlapping scopes of practice. So you as a board have to be extremely careful when you are considering what is the scope of practice. And you as boards, you interpret that language in the statute itself, you interpret that. And where are those lines drawn? And you have to embrace the fact that there will be overlapping scopes of practice. And so to take it outside of your world and bring it into another world I work with in mental health, social workers, psychologists, marriage and family therapists, counselors, where do those scopes overlap and where do they not overlap? And it's an extremely difficult question to answer, especially to those that are not within, let's say, mental health services, or in your guys' world, physical therapy services. And I would point directly to policymakers, politicians, elected officials who are being asked these questions. So we need to understand and separate trade from regulation. That is a direct conflict in my mind, and it surfaces all the time. And it's one of the things that I emphasize most when it comes to board member training. And that is ensuring that you know what hat you're wearing. You're a licensee, you're a member of the trade association, national, state, local chapters, you're a regulator. And how do we separate those interests? Those are all conflict questions. Those are all bias questions. And those are all questions that could surface and create legal issues. So now how do we start to address these issues? Can I be objective in the decision-making process? That's what you are going to ask yourself individually. And as I've mentioned multiple times, this is a personal decision. Now, there will be times when a conflict is obvious, and let's hope these are rare, by the way. There will be times when a conflict is obvious and the individual on your board doesn't see the conflict, or they refuse to accept there's a conflict, and perhaps they refuse to seek some advice and act on that, either recuse or not, or make it a record, or identify some of the facts that need to be identified on the record in order to protect your board legally. So at times that personal decision may have to be forced upon someone. Hopefully, as I've mentioned, it's rare, but you can, as a board, seek to have someone recuse themselves from a perspective of your board operations through motion or otherwise. Now, theoretically, let's hope it doesn't come to that in an open meeting. That's hard to deal with, and that's taken care of in advance to assure that those that may have may be in a position of conflict can identify it, have sought advice, have reacted, and have done or not done something. And there's nothing wrong with identifying in the record the potential for a conflict that is recognized by you as a board member, but you feel that you are objective and you are going to participate in the particular issue or decision-making process. So there are times when you may want to identify that. There are also times when you will identify the conflict and recuse, and you do this all on the record, and we'll address that in a slide there. But regulators, you must ask yourself this question as matters start to surface and come before the board: can I be objective? And your job, by the way, is to be objective. That's why you're on the board. So this next slide says, can we be objective in the decision-making process, meaning the board collectively? Might there be a matter that is of such importance that the temptation is there for the board in unison to say, hey, we are going to interpret the scope of practice to say that only physical therapists can engage in dry needling and nobody else can. That's a bad example. That's something, those are words you should never say, because that is not embracing the overlapping scopes, number one. And number two is it's going to seem like you're just protecting the turf of the profession itself. And as soon as you open that door, then we will see challenges, we will see legal issues, we will see political or statutory issues, and we potentially will see other issues related to media and attention brought to your boards itself. So you can ask it individually, and then you can ask it collectively to yourselves. This doesn't mean that these questions dominate your board meetings, but I am emphasizing them for this hour today to make sure that we anticipate the issues, and when they do surface, you're prepared as board members to address them. So remember that as an appointed person to a physical therapy board, whether you're a physical therapist, physical therapy assistant, or a public member or anything else, you're placed in a position as a fiduciary on behalf of the public. Big fancy word that says that you're placed in a position of trust to undertake the responsibilities that that organization has. In your case, these are government organizations who have been created by statute and who carry out, and you all then carry out the intent of the legislature. Okay, so that's your entire role there. And a breach of that fiduciary starts to threaten the process. So it can do a few things. One is it can create legal arguments for the affected party. So let's call that person the respondent again. And let's say that person had a complaint filed against them, and whatever happens, and there's a licensure suspension, okay, for some reason, or anything else that you might elect to impose as a board. If you, in this position of as a fiduciary, have undertaken the matter without the objectivity necessary, now we've got a legal argument that may be created on appeal that's going to be brought up. And whether that's based upon something that you said, whether it's based on something that's in your past, whether it's based on a direct conflict by competitors or others that we've already talked about, these are all matters that can undo the good work of your board itself. But you have to remember, using this fiduciary phrase, at least, this position of trust you're placed in, you're expected to carry out those, the intent of the legislature in enforcing the Practice Act. This gets back to reemphasize separating trade from regulation. It is extremely important. What is happening in some jurisdictions, and I'm trying to remember now, it might have been California, where there is legislative action to have all public members on their medical board. And whether or not this is a good idea or a bad idea, the point being is that this is a matter of, can we trust licensees to regulate the professions when they are participants within that profession itself? Those are all conflict questions. Those are all legal questions. And one of the reactions to matters that occur that don't look good in the news or that feel like they're protecting the profession is to change the composition of boards. So there's a fair amount of this type of legislation that's circulating around. Will it pass as perhaps, if I can use the word radical, as getting rid of all licensees on boards and having all public members? Probably not, but there clearly is a movement to reduce the number of licensees on boards and increase the number of public members, whether that becomes 50-50 or anything else. The reason behind that is all of these issues we've already talked about. Okay, so I see somebody put in the chat here, California Senate Bill 607. So we all need to be prepared for this. The sky isn't falling, as I've mentioned. However, this is how elected officials, policymakers react to some of the issues that might surface that are driven by conflict questions or the inability to place the fiduciary public trust first and put the professional promotion issues aside. Let the trade associations do their jobs. They're good at it. That's what they're for. And they've been doing it for a long time. If you cannot separate the two, then make a choice and resign one and put your efforts toward the other. Doesn't matter which to me, but it's actually refreshing to hear people talk about that, because it means they understand the differences that we've talked about. So bias and conflict of interest determinations, as I mentioned, they're personal to you. So you are really technically the only one that can decide, can I be objective about this? Can I be impartial in the decision-making process, regardless of the issue brought before you? Secondly, is you identify the issue. And that probably should be first, by the way, but the issue surfaces. And using Deanna's example is, we have a graduate from my educational program. I'm going to recuse myself from decision-making on licensure eligibility decisions because And it's pretty obvious there. But the issue then surfaced, and Deanna takes an action, or perhaps doesn't, but the idea is she saw the issue. I am a big believer in issue identification, not in necessarily thinking you're going to know all the answers. If you don't see the issue, you won't get to the answer because you didn't see the issue to begin with. And the issue may be thrust upon you, but we would much rather have informed board members who can identify these issues and seek the advice and take action or not action. So it's personal to you. You identify the issues, you reflect upon that. Can I be objective or not? And make your decision. You may have to seek legal advice. That legal advice could come from the Attorney General's office or whatever attorney represents your board. On rare occasion, you may want to seek legal advice on your own. But the point is you may need some advice. That advice may also come from the board chair, depending upon the circumstance, and it may come from the board executive director or administrator, or a combination thereof, in order to get to the so-called right decision, whatever that decision is. If you do all of these things, you'll make the right decision, period. So you seek that advice, you re-reflect based upon the advice, and you either act or don't act, okay? And as I've mentioned, when you recuse, do it on the record as soon as you know about it. You don't need to give a lot of details. You would just say, for purposes of objectivity or impartiality, I am going to recuse myself from the matter. So let the record reflect that I am leaving the room, and out the door you go. When you do recuse, I don't recommend you stay at the table. I don't recommend necessarily you even stay in the room. I would leave the room and let the discussions be had, and ultimately a decision is made. The reason that I am a little conservative about that approach is I don't want lawyers to say you were in the room and that you were influencing the board by, whatever, huffing and puffing, making faces or waving your arms in the back of the room. So the safest way is to leave the room. If you decide not to, fine, but do it on the record. You don't need the details, just purposes of objectivity, and note the time so that when I read your board minutes, I know that you recused at this time and you no longer participated in the matter, in the issue. So how are we doing? Questions or anything? Any comments to be made so far?
Dale, isn't it pretty tough to see the conflict of interest in yourself, and probably very easy to see the conflict of interest in others?
Yeah, I suppose that's true, but I still suggest that it's a personal decision. You can't tell me that it's hard, I should say, for you to tell me that I cannot be impartial on this particular matter. So it's your golf partner, and versus it's somebody who graduated from the same class as you 3 years ago. It's a good point, but I like to place the emphasis and the responsibility where it belongs, and that's on you. Okay. As I've mentioned, occasionally it might come up where someone doesn't see the conflict and the difficulties that come out of that. So as I've mentioned, was there other question or comment?
Yeah, I'm on the investigative committee in North Carolina. And when we bring the information to the board and make our recommendation, then I recuse myself from the vote. I don't typically, we haven't been having that person leave the room. Do you, in that case, is it important or?
It may or may not be. And depending upon the circumstance, if you're going to a hearing, you may be a witness at some point if you're on the investigative committee. So you may be asked to testify about certain things. Is it important to leave the room? Again, I am ultra cautious on that. And so, just make sure that you're not participating or looking like you're participating. Just don't give fodder to defense lawyers to challenge the process that was undertaken. But you're doing the right thing. You're doing the right thing about recusing, obviously, as the matter comes ultimately before the board itself.
Okay, thank you.
Sure. So, and by the way, everybody follow the advice of your lawyers. This is Dale here having a little fireside chat with you all, but if these questions surface, feel free to run those past the lawyers. Hopefully what I give you is enough to help identify the issues. You articulate those issues to staff or lawyers or administrators, or all three, and then you ultimately get your decisions made. So while we're on this
Bill,
slide,
Bill,
Yeah, go
excuse me. We have a question on the chat. I don't know if you can see it.
what if you think you can be impartial, but the perception of others is that there may be a conflict? What do you suggest you do? Yield to peer pressure or hold your feelings? Okay, or hold to your feeling that you do not have a conflict. Again, I'll stand by what I said. This is a personal issue, and I don't think you should ever be browbeat into recusing yourself from a matter. However, if someone brings something up from a perspective that you didn't think of and it changes your mind, there's nothing wrong with that either, that you recuse at that point. But it's hard for me to think of an example that you personally haven't already reflected upon and thought of those examples. So I think the way you phrased your question, don't give in to peer pressure, never, not at all. You're there to do your job, and recusals have consequences, which we're going to talk about on this slide in just a second. So no, I don't think peer pressure should come into play. It should be pressure. Pressure isn't a good word. It should be your decision, personally, that you feel you can or perhaps cannot be impartial or objective on the decision. So, and the reason that I'm cautious about it, and I'm glad you phrased it this way and asked this question, and that is because there are those that will attempt to pressure you into either making a decision that's consistent with what they want or to get you out, because they know you may vote against something that they want. So, and I realize these are vague statements, but there are people that certainly would want to assure that recusals occur in order to probably try to assure that the issue passes if I want it to pass, or doesn't pass if I don't want it to pass. So peer pressure is a good phrase. I'm glad you use that. You should never give in to that. Similar to that, by the way, while we're on this topic, it's like intimidation as well. Oh, I'm going to sue you. I'm going to sue the board. You should never be intimidated by threats of litigation. You should stand your ground, do your job, and make the ultimate decisions, whatever they are, in the interest of public protection by enforcing the Practice Act itself, consistent with the intent of the legislature. You guys can develop your speeches like that, but yeah, there should never be a pressure issue that's brought to bear. If there is going to be a pressure issue, I know I'm droning on here. If there is a pressure issue, it should come internally, not from external sources. So in other words, the board may want to know or ask a question or two. So you'll get used to these issues, I think, and they should be a part of every board meeting where there's opportunities to identify conflicts and provide opportunities for recusal or otherwise. So good enough, I hope, on that. While we are on this slide, know the difference between recusal and abstention. Recusal, you do not participate in the discussions. You do not influence the board whatsoever. As I've mentioned, you recuse on the record, and you potentially leave the room or certainly remove yourself from the process, whatever that is determined to be. Abstention, you may participate in the discussions. You may get all the way to the vote, and then you decide you don't want to vote. Okay. Now, to me, there's rarely a reason to abstain from a vote, ever. But occasionally somebody brings up an example, and okay, I can live with that. But make sure you understand that recusal is not participate at all. Abstention, you may participate perhaps, and then you don't vote. But don't chicken out on any votes on very difficult issues, because that is not what you were put on the board to do. And that's not why you collect those big monthly paychecks you get from serving on those boards. I know that's supposed to be funny, so you guys can laugh out loud if you want. Abstention is probably something that should rarely be used, if ever. And the one example I can think of to try to identify is you missed the last board meeting, and the motion comes up at the next board meeting to approve the minutes of the last board meeting, and you say, I wasn't there, so I'm going to abstain from voting. I don't even believe you should do that. I believe you should say, I've read the minutes, and if someone is making the representation that these are a true reflection of what occurred at the last meeting, I'm going to vote in favor of passing the minutes. So, but that's just an example of maybe where we could start to identify a potential reason to abstain from voting. So, anyway, those are the differences between recusal and abstention. Sometimes they're used interchangeably. They shouldn't be, because they have very different consequences to the board itself. Other questions or comments? I'm going to talk about just a couple of cases here, and I have to reach for my phone to see what time it is. Where am I watching? All these windows are blocking my time on my computer. Okay, so individual bias. This Stevers versus Pierce case is a great case. It's from 1995. I'm using old cases to identify issues because they kind of set the standard for how courts look at some of the newer issues. But the Stevers versus Pierce case is a perfect example of an individual who was the chair of the board and was leading the board on matters related to an applicant for a private investigator license. And what had happened was the chair of the board and the wannabe licensee was coming from Massachusetts, coming from another state into Nevada. The wannabe licensee and the chair of the board had a business relationship that went sour and south. And secondly is the applicant for licensure wanted to bid on a contract that the chair had with, which was a big contract for purposes of private investigator services. An obvious conflict, and this board chair did not recuse, and not only did not recuse, participated in the discussions and made some of the motions that resulted in this applicant not becoming licensed. And in the end, the court fixed all this and clearly identified these conflict positions. But what I like about this case, not necessarily is that all this happened, I don't like that, but what I like about it is the court identified how one board member can influence multiple board members. So that was the important issue related to individual bias or conflict here, that the court was concerned that there was an undue influence on the rest of the board, especially because this person sat in the position as the chair and could guide the discussions and call on people or not call on people and things like that. So it's a good example of individual bias, number one, and two is how that person may influence the rest of the board members. This is an extremely famous case from 1973, Gibson versus Berryhill. And the bottom line to this case is, this is the US Supreme Court decision that said the appearance of bias may be enough to cause a violation of one's due process rights under the Constitution. So this was a optometry case. The facts are very interesting. I won't have time to go through them, but the very short version of the facts are that in Alabama, back in the late 60s, early 70s, optometrists were prohibited from working for corporations. Okay, they had to be individual practitioners. The trade association, the state chapter of the trade association, only allowed people in who had independent individual practices and did not work for, say, Lee Optical. Okay. The composition of the state board itself had to come from the trade association. So those are all independent practitioners. None of them work for corporate employers as well. And lastly, if this statute was enforced as interpreted by the board made up of independent practitioners, half of the optometrists in Alabama would be subject to discipline because they work for corporate employers. Okay, so you can see now the buildup here. And the ultimate bottom line in this case, to save us some time, is the Supreme Court agreed with the lower court, the district court. This isn't federal court, by the way, obviously, and it went up to the United States Supreme Court, agreed with the district court that the perception of bias here was strong enough to implicate the constitutional due process rights. And so this is the case that's always cited for purposes of saying the appearance of conflict may be enough, not just actual bias or actual conflict. So this is a case that's worth reading, and perhaps we can do another seminar where we talk very detailed about this case itself. But in the end, appearance is enough, and the Stevers case is the influence of other board members by an individual. So here in the Gibson case, the court very clearly said, the makeup of the entire board, we can't trust you, because You're all independent practitioners. You're interpreting a statute that says no one can work for corporate entities. If you disciplined and took away the licenses of half the optometrists in Alabama, you know what would happen? Economically, you would benefit. Somehow the board would. And so there's this direct conflict eventually as well about financial gain made to the board members itself. So a couple of cases that are good readings. I know they're older, but they are certainly relevant today's day and time to get the conflicts identified and help guide us related to when we should recuse and perhaps when not. So I put the slide up again one more time. It's personal. Identify the issue, reflect, seek advice, re-reflect, and act or don't act, and you should be in good shape. The last thing I'll say, and this isn't to end this session on a scary note, but if you are in a position of bias or conflict and you cannot be impartial in the decision-making process, one might argue that your immunity protections go away or start to wither away because you did not recuse yourself or did not identify that. So the ultimate legal leverage that your lawyers would have is to talk about immunity that may not apply if you're unable to see the conflict. And that's kind of back to Rich's question, is it personal versus others see it easier? So that may surface eventually, but are there any comments or questions that anybody has about anything I've said or anything that you would like to bring to the attention of the attendees? Remember, learn from each other. Super beneficial. The FSBPTs of the world, the idea is to bring you together and to have these kinds of discussions. So I hope I didn't talk too much, and I hope you all got something out of this. And I would end my remarks by, unless there's any questions, I end my remarks by reiterating my thanks to each and every one of you for the important role you play in public protection. And many, many thanks to FSBPT, its board of directors and staff for putting on these regulatory hours on a monthly basis. So any final comments or questions from anybody? We're kind of right on time here. Ruggie, how'd we do, huh?
We did excellent. Thank you, Dale. And we do have like 2.5 minutes left for any questions. So I'd like to open the floor for any questions at this point. I'm just waiting a few seconds to.
I think we did such a good job, Ruggie, that we probably answered all their questions in anticipation.
Well, I do have a question. If you were the AAG of the North Carolina Dental Board, with those teeth whitening kiosks, cease and desist orders, how would you advise them?
Well, I think that that everyone should be familiar with the dental board case, went to the U.S. Supreme Court. That's an immunity case. I'm not afraid of cease and desist orders or letters from regulatory boards, so long as you have the statutory authority to enforce them. So it's really a matter of unlicensed practice and administrative authority. But I would not be dissuaded from cease and desist letters.
Excellent. We have a question here.
Yeah, I see the question on successful cases against PT boards for conflict of interest. I searched and I have very robust access to a robust data bank. I didn't find any cases. I didn't go back as far as perhaps I could have. But that's a great question. And believe me, I would always search this question on the topic related to the profession that I'm going to speak to. I did not find any. They didn't jump off the page at me, at least, but I would keep looking. And Cindy, if I find one, I will bring it to the attention of FSBPT and they can share it with all of you. Which, by the way, last point for me is these slides are available to you. So feel free to take advantage and use those if you think it would be helpful.
Any other questions? Thank you, everybody. And please do not forget to fill up the survey. That is very helpful to navigate future webinars. I would like to thank Dale for his continued support for FSBPT on behalf of the board. And we have a minute left. So if anybody has any other questions, I'd love to entertain that. That being said, it is almost 2 o'clock. Thank you, Dale. And we'll see you again in future webinars.
Thank you, everybody.